Hi everyone, so basically the class is about Supreme Court of India. Supreme Court of India. If we talk about this, the Supreme Court of India is the highest court that we have in our country. We have basically the Supreme Court at the top, then below it we have the High Court, then below it we have the district courts, and lower than all of these we have the subordinate courts. Subordinate courts. All right, so if we talk about these four type of courts that we have in India, Supreme Court is the top level highest court in India. Then we have high court. High court is present in each state of India, and some states have one high court in common, and the example is Punjab and Haryana. It have a one high court in Chandigarh because it is a tri-city and two states share a common capital. And then we have district courts, which is present in each and every districts that we have in a particular state. All right, so now here we have to discuss about the Supreme Court of India. This is the final court of appeal, which means that above all three courts, the High Court, District Court and Subordinate Court, the decision of Supreme Court of India is final. For example, if a case is gone under the hand of High Court, all right, and if it gives its answer, advice to that court, and the person who has been involved in that case is not agreed to that, then they can move to Supreme Court, and above it there is no other court. So now the case will be judged by Supreme Court, and whatever the decision Supreme Court takes, it will be the final decision, and no other court is there to be challenged except the Supreme Court. That is why it is called as Supreme Court of India. So now if we talk about it, there are some basic understanding that we have to make sure that we know. Supreme Court of India has been established in 1950. 1950 में 1950 में it was established, and it is basically hold the rule of law, okay, and protect the certain things, rights and rules that is given in the constitution. It has the main focus that whatever is given under the Constitution of India, if we talk about the law, if we talk about the right, if we talk about fundamental right, it is the duty of Supreme Court of India that it makes sure that everything is followed by the power below it consecutively, right? So now if we talk about Supreme Court, it is there, its office or headquarter is there in New Delhi, which is the national capital of India. That is why it is situated in New Delhi. Being a capital of India, country as a whole, make sure that Supreme Court will be there in New Delhi only because it is the highest and the final court of appeal, whereas High Court is present in each and every state. Remember that Supreme Court of India is only there in New Delhi and not in any other place in India we are talking about. All right, but High Court can be seen in each and every state except in some cases where the High Court is common for two or more states. So I hope these things have been understood by you. All right, so the Constitution of India provides power to the Parliament that it will make sure how many judges will be present in Supreme Court. So as per it, under Article 124 of Indian Constitution, under Article 124 of Indian Constitution, the Parliament can increase or decrease the judges of Supreme Court. The Constitution of India gives Parliament the power to increase or decrease the judges of Supreme Court. It can either with the need of time, increase it. When there are more cases pending, when there are more need of it, then Parliament can give the permission that yes, more judges are required in Supreme Court of India, so it could be increased. And if there are less work or cases are not there, not pending, then the Parliament can give other permissions or advice to decrease the Supreme Court of India judges. Alright, so the Parliament passed several acts for judges of Supreme Court. So as per it, 34 judges should be 34 judges should be there in Supreme Court, including the CJI. Now, what is CJI? It is the Chief Justice of India. So, just the way Supreme Court is the highest court of India, above High Court, District Court or subordinate court, Chief Justice of India, or in short we say CJI, is the highest judge among any other judges. So here we are talking about CJI of Supreme Court. And here High Court CJI is also present. We have CJI at High Court and we have CJI at Supreme Court. Only these important CJIs have the power that they can, with Parliament or with the permission of Parliament, being the support system of President, they help to appoint other judges of Supreme Court. Like CJI will always be involved in the appointment of other judges of Supreme Court with President of India. This is the most important fact about CJI, which exists in Supreme Court. Another important thing about Supreme Court is that the judges in it is appointed by the President of India. Very important fact that you have to keep in mind, that Supreme Court judges is appointed by the President of India, and they leave their office or they get the retirement at the age of 65. Keep that in mind, that the judges of Supreme Court get retirement at the age of 65. And then whenever the judges of Supreme Court are getting allotted at their role, they are always consulted by the President with the CJI of that court. Which means, for example, we have CJI present, but now we have to appoint the other judges. Here we know that 34 judges are there in Supreme Court with total, right? So except CJI, we need 33 more judges of Supreme Court. So for these 33 judges of Supreme Court, we have to consult the CJI. The President have to consult the CJI for these 33 judges allotment, that yes, we are considering these candidate to be at this place, that they should be there at the Supreme Court judges place. What should we do? Should we hire? Should we allot them? And then with the CJI advice, with the CJI permissions, if they find it suitable, they appoint these 33 judges. And if there are some misconception or if there is some allotment of it, then they do their discussion, and then with the discussion with CJI and President only, these judges of Supreme Court get allotted. Okay, so now if we talk about the appointment of Supreme Court of India judges, so under Article 124 Part 3 or Clause 3 of Constitution of India, it is given that if someone or some candidate want to be the Supreme Court judge, he or she should be the citizen of India. The most important requirement is you should be the citizen of India if you wish to be the judge of Supreme Court. And then there also, so if you have practiced as a judge in High Court for 5 years, then you can be the Supreme Court judge. And the other criteria is if you have practiced as a lawyer for 10 years. For 10 years, if you have practiced as a lawyer in High Court, then also you're eligible to be the judge of Supreme Court. So if anybody in India wish to be the judge of Supreme Court of India, then under Article 124 Clause 3 of Constitution of India, it says that citizen of India should be a must. And then High Court judge as 5 years, and then 10-year lawyer in a High Court is a must requirement. After allotted as a Supreme Court judge, the candidate have to take the oath that being the judge of Supreme Court, I am going to be true to the Constitution and so, and they take the oath in front of President. Very important thing that the Supreme Court judge take the oath in front of President of India. Another thing that we have to keep in mind is that the parliament so the parliament is responsible for more than anything related to Supreme Court of India. Here we talk about parliament is responsible for Supreme Court judges appointment. If Supreme Court judge have to be appointed, it will make sure by the parliament. The salaries of Supreme Court judges will be make sure by parliament. The allowances, which means, what does allowances mean? That the extra facilities like medical facilities and DA facilities, there are many facilities that the Supreme Court of Judges get, and they all are decided by the parliament for them. And then we talk about leaves. If somebody is in need of leave, it is a responsibility of parliament that they grant the Supreme Court judges the leave whenever they required. And then there are the very important thing that we have in the government services, mainly that is the pension facilities. Yes, the Supreme Court of India, after retirement at the age of 65, they get pension, which is the money, half of the salary that they were getting paid when they were at the seat, when they were having that position in the office till the age of 65. The half salary will be given in form of pension till their death. All right, so I hope these things has been clear to you, which is the very basic and the most important thing that you have to keep in mind. Now we have the acting Chief Justice of India, which is also the same thing as acting Chief Justice of Supreme Court. Whenever we say Chief Justice of India, CJI, so now you all know that Supreme Court is the highest above all courts. So CJI of Supreme Court is highest than the CJI of High Court. I hope this is very sensibly clear to you. So now if we talk about acting Chief Justice of India, here under Article 126 of Constitution of India, 126 Article of Constitution of India says that other court judges is appointed by President with the consultation of CJI only. And then another we have the term ad hoc CJI. So ad hoc CJI under Article 127 talks about ad hoc Chief Justice of India or Chief Justice of Supreme Court. It says Supreme Court judge will continue in session, that whenever the Supreme Court judge will continue in session, it is under ad hoc 127. For this, under 1993 session, second session of judges case, there were two major cases related to it, that we have one in 1993 second judge case. In this, CJI consulted. So in 1993 second judge case, CJI is consulted by the President for some advice, and that advice is binded on President of India. It is compulsory on President of India. Then again in 1998, another third case of CJI got happened, which says that the consultation with CJI is a must, but that CJI will consult. Previously, in the 1993 second judge case, it was said that the President will consult CJI, and whatever advice CJI will give, it is binded on President. But here in 1998, it got changed. It got changed as the CJI will now have to consult with other senior Supreme Court judges, and after that it will advise the President, and then the President will make sure that advice that CJI has given to it. And this is known as, this method is known as collegium system. So this was one of the most important method that we got related to Supreme Court judges or CJI judges in 1998. I hope this much is clear.